So you can't see this, but hopefully you can hear it. Behind every Boise State Public Radio podcast is a team working hard to bring you stories that matter. So if you value podcasts like this one, please support them. Hit donate at boisestatepublicradio.org. Thanks.
More Idaho Matters now from the studios of Boise State Public Radio News. I'm Gemma Gaudette. Idaho's largest health system, St. Luke's, filed a lawsuit last week in U.S. District Court suing Idaho Attorney General Raul Labrador. The health system is seeking to extend court protections that have allowed for emergency abortions despite our state's near total abortion ban. So joining us today to talk about this lawsuit and why it was filed is Peg Doherty. She is St. Luke's Deputy General Counsel. Peg, nice to have you on the program.
Thank you, Gemma. It's nice to talk to you again.
So, Peg, why did St. Luke's decide to file this complaint?
Well, the Trump administration has made clear that it does not intend to protect reproductive health care at the federal level. So we expect that it will not continue its challenge of state abortion laws, including the existing case. What we anticipate is that the United States will seek to dismiss its case, and thereby the current injunction that allows our emergency room physicians to stabilize a pregnant patient's health if they present to an emergency room with an emergency medical condition would go away. And our emergency room physicians then would be left in a position of only being able to offer termination if that's what's medically indicated, if it was to prevent the death of the pregnant patient.
Peg, can you give us a little bit of history of the conflict and the different court rulings on this matter?
Sure. It's a bit of a ping pong match here.
Mm-hmm.
It started with the Dobbs decision, which overturned Roe v. Wade. That triggered Idaho's abortion ban law to go into effect. So this was back in June of 2022. Before Idaho's law went into effect, the United States, through the Department of Justice, filed a lawsuit in federal court seeking an injunction that would allow Idaho's emergency rooms to stabilize patients' health despite Idaho's abortion ban. That injunction was granted. And by the way, the law that we're talking about here is the Emergency Medicine Treatment and Labor Act, otherwise known as EMTALA. And that's the federal law that says that anyone who presents to an emergency room must be given stabilizing care within the capacity and capability of that hospital.
Mm-hmm. So with that,
sorry, go ahead.
No, go ahead, Peg. Sorry.
The injunction was granted back in August of 2022. The AG and the legislature appealed that decision to the Ninth Circuit. It was taken up by a 3-judge panel in the Ninth Circuit who lifted the injunction, and that was immediately appealed to it's called an en banc panel of the Ninth Circuit, which is a larger panel of judges. That en banc panel reinstated the injunction, which was in place until January of 2024, when the AG's office sought for the U.S. Supreme Court to hear the case. The U.S. Supreme Court lifted the injunction until the case was heard in April of 2024. The decision from the Supreme Court came out in June of 2024, reinstating the injunction, which is where we are today. They also remanded the case back to the Ninth Circuit. Oral argument was heard on December 10th, and we are awaiting a decision out of the Ninth Circuit right now. So I know that that's been back and forth a lot, but that gives you an idea of what our physicians have had
Yeah.
to deal with as well. The injunction's been in effect, and then it's been lifted, then back in effect, then lifted, then back in effect.
So, Peg, if I'm understanding this properly, because as you mentioned, it's been a ping pong going back and forth, are abortions able to take place if the health of the mother, the life of the mother is in jeopardy, an emergency abortion? Can that happen now here in Idaho?
Now, yeah, right now in Idaho, if a pregnant patient comes to an emergency room with an emergency medical condition that's related to that pregnancy, they are given a medical screening exam. And if the physician examining them determines that the medically indicated treatment to stabilize them is to offer termination of that pregnancy, they can do so. And if the patient wants to go ahead and terminate the pregnancy, they can do that even if it is to stabilize that patient's health.
Mhm.
And so that's different from Idaho law, which says that they could only perform that termination if it was to prevent the pregnant patient's death.
Mhm.
So right now, in emergency rooms, stabilizing care to preserve that patient's health can happen.
So, St. Luke's files this lawsuit last week. Your concern is that what you just described may be taken away because you believe there is a conflict, correct, between the state and federal laws. And if that is the case, can you explain why you see a conflict?
That is correct. Yes, we do see a conflict because the federal law, EMTALA, says that anyone who comes to an emergency room deserves to receive stabilizing treatment for their emergency medical condition. And federal law defines an emergency medical condition as one that would place the health of that person in serious jeopardy. So federal law is pretty clear that stabilizing treatment, whatever is medically indicated, should be provided to a patient who comes to an emergency room to address their health condition. Um, Whereas Idaho law only allows, in the case where termination of the pregnancy is indicated, that a physician can only perform that termination if it is to prevent the death of a pregnant
Mm.
patient.
What are the next steps in this case?
Well, the court has set a hearing on our motion for the injunction for March 5th. So the next steps right now are to prepare for that hearing on March 5th. The injunction, we believe, will remain in place until then. And so we will be preparing for that hearing.
Mhm.
I will also say that St. Luke's is continuing to advocate for a legislative change to Idaho's law so that it would include an exception for a pregnant person's health. It would allow for an abortion in the event that a pregnant person's health was in jeopardy.
Peg, if there was, I have about a minute left with you. If the legislature made that change, it would seem to me that this lawsuit and everything could go away.
I agree with that. I think that if there were such a change to our legislation that would include an exception for emergencies that jeopardize a pregnant woman's health, then this lawsuit would probably not be necessary.
So, very quickly, how have all of these changes in the state's laws impacted retention and recruitment of doctors who specialize in women's health care?
Yeah, when it first happened, we saw many obstetricians and maternal fetal medicine specialists leave the state. There's been concerted efforts by several health systems to recruit, which has required really bolstering the incentives to come to Idaho to practice medicine. And we've slowly but surely increased our specialists in the obstetrics world because of these enhanced incentive packages that we've been able to offer. But it's been tough, and there still is a shortage.
Well, Peg, I want to thank you so much for taking time to talk with us about this. We've been speaking with Peg Doherty. She is St. Luke's Deputy General Counsel, talking about this lawsuit filed against the Attorney General of Idaho. And that'll do it for this episode of Idaho Matters. Thanks so much for listening. And just a reminder, you can find all of our episodes wherever you get your podcasts.
If you like podcasts like this, explore more from the Boise State Public Radio podcast family. There you'll find a mix of daily news, Idaho Voices, and in-depth series on a wide range of topics. I'm talking wild horses, political scandals, sustainable ranching, and militia groups in a post-January 6th world. Wherever you get your podcasts, just search Boise State Public Radio to find what Idaho's NPR station has in store for you.